5 minutes past 10. David Whiting, our talkback lawyer, is here to take your calls and help you with free legal advice. 1300 222 774. 1300 222 774 is the number if you would like to seek some free legal advice from David Whiting. Morning to you, David.
Good morning, John.
Couple of things. The legal system is very much in the spotlight during this state election campaign. In particular, Matthew Guy announcing just the other day, on Monday, we had the Shadow Attorney General, John Pisciuto. Oh, it was yesterday. Seems like ages ago.
It does, doesn't it?
Saying that if elected, a Liberal government will make more information available about judges, their performance, the delays and sentencing that they hand down. The sort of information at the moment that's held in the Justice Department, and they'll make it all public.
Don't really have a problem. I just wonder, John, whether some of the numbers that they propose to present are in fact indices of quality and effectiveness, as opposed to how many number processing there are. I mean,
well, Matt Collins, QC from the Bar Association, joined us yesterday and said, no, that's reducing sentencing and the administration of justice to a set of metrics, which doesn't know justice at all.
Well, can I say I agree with him? The answer, I mean, if you sit on a nine-month case, are you expected to produce your judgment in how many days?
And the fact that you've heard 2 trials in a year doesn't mean you're lazy or unproductive. It means they might be very long and complex trials. Well,
John, you sometimes go into the practice court and you'll find that
people don't know what the practice court is.
They hear what I'll call quick matters, and they do process planning for other matters.
And bail appeals from the magistrates' court, things like that.
But there might be 50 matters listed for the day.
Yep.
And my experience is that the judges read the material before the barristers get up to speak. And that's an incredible amount of non-court time.
Oh, yeah.
What do you measure?
You have to get across a whole lot of stuff and whip through it, whether you like it or not.
Or you're interviewing an expert tomorrow and there's a 400-page expert's report, which you really have to be familiar with it before you start the analysis.
Otherwise you don't understand a word of what they're saying.
Yeah, so I thought I didn't really have a problem. My difficulty was that all you're getting is a series of headlines and you're probably not measuring the right things. How many people are appealed? Well, my question is not how many appeal, but how many win on appeal.
Sure.
Might be the
I don't
test.
have a problem with releasing more information about the legal system. In fact, quite the opposite. I'm an advocate for releasing as much information about the legal system as possible, because that way people understand it better and stop complaining about things that, in fact, they haven't understood.
Yeah.
So the legal profession, I think, have to do a much better job, and the judges in particular, and the courts have to do a better job of explaining themselves publicly and in language people can understand.
Well, you can now get lots of judgments on a website, Austlii, austlii.edu.au.
And some of them make sense when you read them and some of them don't.
Yes, yeah. Some of them are shorthand.
Yeah, and some of them, there are some judges who say in several hundred pages what could just as easily have been said in a couple of dozen pages.
Yes, or hundreds of paragraphs when they measure them in, John, rather than pages.
Yeah, but it's completely, sometimes it's over the top and it's a bit of vanity and a bit of look how much I understand things, or look how much I know, or look how I'm writing out here a textbook on how the law should be applied in the future, instead of just solving a problem before the court.
So yes, I'm all in favour of let's have more information, but let's be careful about what the information is.
Other things?
Meaningful. Well, John, I had 2 lighter matters. One is an adverse possession claim out of Sydney that was reported last week.
So explain adverse possession.
Adverse possession is when I occupy a property, not owning it, and after a period of time the rights of the owner are extinguished and I become the new owner.
So if a fence is in the wrong place or there's a vacant block of land and you enclose it,
yes,
add it onto your property, and over a period of time no one says anything, it becomes yours.
Yes. What you do is the rightful owner loses the right to make a claim to take possession of the property from you.
Yep.
Therefore, you are the effective owner and you can get a title. Now, there was a report last week in Sydney about such a property in Sydney that a man saw was dilapidated and run down and had nobody living in it in 1993. He then tidied it up, did what needed to be done, put in tenants, started collecting rent, and last year applied for a title by adverse possession, which was opposed by the heirs of the person who had last lived in it in 1947.
19...
47.
And
It
they'd
had
left
been a
it?
while. No, but there'd been tenants in the meantime.
Okay.
But it would appear that there'd been no tenants in it since the 60s, if not earlier.
And they just forgot about it, or...?
The family knew they owned it, but it wasn't a topic of conversation for some reason.
Sorry, people own real estate that they don't think about for 50 years.
Yes. Well, sorry, don't do anything about it. They might think about it, but they don't do anything about it.
Right, I don't quite understand that mindset, but then there you go.
Well, having said that, John, and we're talking about this one in Sydney, I've done such an adverse possession claim in Hawthorn, where there was a house that was empty for a lengthy period of time. My client saw that it was empty, and he effectively moved in. His daughter stayed there as a tenant.
So, sorry, he squatted?
He squatted. He squatted for 17 years, and we made an adverse possession claim. And the client now, as far as I know, still owns the property.
In Hawthorn?
In Hawthorn.
Real estate in Hawthorn being...
Oh, John, this was a few years ago. It isn't quite what it is today, but it's still, amazing. In a sense, his true costs were my costs and the surveyor's.
Sure, but free house.
Yes. Yes. So Hawthorn, yep, absolutely.
Okay.
And the other one I wanted to talk about, John, is we bring actions against people, and the law considers that a corporation or a company is in fact a legal person.
Yep.
So there's always a plaintiff, but the plaintiff might be the state, and there's always a defendant, and the defendant might be a government department. It might be, but it's still a legal person. It has legal personality. But it's also possible to sue a thing. And they're called actions in rem, R-E-M.
What do you mean, sue a thing?
You sue a thing. So, and they normally involve ships.
Yes.
So there are lots of actions brought against ships. I have actually arrested a ship once. That was a lot of fun. But, so you commence proceedings against a ship. Yep. In America, they allow you to commence proceedings against stuff that doesn't appear to have an owner. And can
you explain the context? What if you get hurt by...
Well, a couple of years ago, the government in Indiana seized 1,855 pounds of American paddlefish meat and 982 pounds of American paddlefish caviar. Now, we don't know who owned it, so we can't sue someone to take the property from them, so we have to sue the property. So there's a case in the United States at the moment of the United States against 1,855 pounds of paddlefish meat and 982 pounds of American paddlefish caviar. Now, if you want to know, so you sue them, well, should the government prevail, which seems likely, the court will issue a warrant for the defendant's arrest, although they're already in custody. Judgment will be entered declaring the defendants shall be forfeited to the government. So that's the process. The defendants won't appear. Their property will be seized. That'll be the end of it. And the United States government will then be the owner of about a tonne of 2-year-old paddlefish meat. But the bit that got me in the news article was other interesting cases. There is the United States against approximately 13 unoccupied burial plots situated at Forest Lawn Memorial Park, Hollywood Hills.
That's the title of the case.
Yes. Yep. Yeah. And there is... United States against 11 1/4 dozen packages of articles labelled in part Mrs. Moffat's shoe fly powders for drunkenness. So, one could say only in America, but, they're beautiful. So it's an action in rem. Thank you, John.
David Whiting taking your calls, 1300 222 774, 1300 222 774. Stephen, South Gippsland, good morning to you.
Good morning. Mine's not quite as colourful as that, I'm afraid.
No, most aren't.
No. David, I've been issued a charge sheet and summons. What happened, silly me, I was backing into a car park at Traralgon station to go down the football. It was very tight. I pulled out, then reversed back in, and I nudged the car.
Yes.
I did minor damage to it. But I didn't leave my name.
Yep.
On the vehicle, and I didn't go to the nearest police station, which I didn't realise I had to.
Yes.
Now, so I've got this charge sheet, and I'm due in court in December. I mean, I'm going to plead guilty. I've already said I was guilty with the statement with the police.
Yes.
Is there for something? I mean, I think it's pretty minor. Would I need a lawyer to go to help me with this, or do you think I should represent myself?
Well, there's two parts. The first is, do you know what the damage is?
They sent
If you run into my car, it would be causing damage of $320 to David Whiting's car, right?
Yep.
So what have you done in relation to the damage?
Well, nothing, because I've only just found out. I've got to go to court.
The magistrate needs to work out what an appropriate penalty is.
Yep.
So one of the issues is, what have you done about the damage you caused to the car that you hit?
Well, when I was interviewed by the police, in the police statement, I did state that I apologised to the owner of the car and I would pay any damages that were needed, but I haven't heard anything.
So I would...
See, I don't even know who the... Well, now I know who
because the person's name will be in the summons. Why don't you approach the police and ask for two things? Yep. You'd like the opportunity to pay for the cost of repairs.
Yep.
And you'd like the police to see if you're eligible for the diversion program. Now, the diversion program, if you're successful, will mean that... So you'll need to pay the compensation, you'll need to write a letter of apology to the car owner, and then the police need to recommend you as being suitable for the diversion program.
Okay.
All righty, Steve.
Which means what, though? What's the diversion?
Well, if your diversion program means that the charges will be shown as withdrawn.
Okay.
I can't believe that. I mean, really, it's also trivial.
But it's not a ticket offence, John. There will be no infringement notice.
No, but it's also trifling.
It depends on how hard he nudged it.
Well, no, but
look, the damage wasn't major, I can assure you.
No, and for this to become a police issue, I'm astonished, quite frankly, Steve. But David's advice is you can deal with it the best that way, okay?
Okay, thank you very much.
And if you go to court on your own, Stephen, and for that penalty I probably would, I want you to be able to go to the court and say, I have made restitution, I have paid the cost of repairs.
So the court knows not to make any bigger fuss about it. Sue in Malvern, good morning to you.
Good morning. Thank you for taking my call. My question is how to get landlord insurance when the tenant now chooses to be on a periodic lease after the fixed term agreement has expired. All the insurers I've checked cover rental default and rental loss after a risk event that makes a property uninhabitable, provided a rental agreement is in place. I'm in a predicament.
Well, why don't you ask the tenant to go on? So I suppose the answer very simply is that if you're not on a fixed-term lease arrangement, the tenant has the ability to leave on short notice. So you're not lost any rent if the tenant elects to leave. That, to me, would be the issue. So you own a property, there's a tenant in there, the lease is coming up for renewal tomorrow, the tenant leaves today and there's a damage at the property which gives rise to an insurance claim. What's your loss of rent? So I suppose it's lost opportunity rent. It's not available to rent. That becomes harder to assess from an insurer's point of view. But why would you not? You could enter into a fixed-term tenancy agreement with the existing tenant.
Yes.
And you could even include a provision that if they wanted to go on a month's notice, they could. And that would get over your problem. All of a sudden, you'd now have a fixed-term tenancy agreement.
Okay, so put in a clause that they could just give a month's notice.
Well, I'd certainly look at that. I'd look at the insurance policy to see what a fixed-term tenancy agreement is. But the tenant can go anyway if the property is unsuitable for habitation.
Yes.
So have a talk to the tenant. I can understand the insurance company's point of view. They might end up paying for something that's never going to have anybody in it for issues that are not to do with the tenant.
Yes, that's not my situation, but in any case, I'm afraid that if there was a fire or something and it becomes unleasable and the insurers say, well, you didn't have a fixed term agreement in place.
And that makes it almost impossible for you to prove your loss because in the absence of a lease, what you are is you're a building owner with a property that's not habitable. There's no evidence of loss in those circumstances.
So is this a commercial property or a residential property?
Residential. Okay.
All right. Well, good luck with that. And that's the advice that David can give you. Brian in Coldstream, good morning. You're next.
G'day. Question about use of a private road. I live off a local road. There are three of us that live on this private road. We have to maintain it.
So when you say a private road, you mean it's a council road that council doesn't want anything to do with?
Correct.
Yes.
That's the way that I believe it. Now, one of the residents on the road is proposing a commercial project on his property. He has two access points to the property. One of the access points is jointly owned and on title with two people.
So one is via a road and the other is via an easement. Is that right?
Correct.
Yes.
Yeah, correct. And that shared easement, the guy that he shares that with has denied him right of access for this commercial project. Can we, the other two
users, if you like,
yes, co-users,
yes,
can we deny the third party right of access for a commercial project?
No, it's not your road.
Right.
So the short answer is no. Well, you choose to maintain it because otherwise your vehicle will get ruined. But you don't technically have to maintain it. Why would you not talk to the council and get the council to consider whether there might be some conditions on the permit about access to the property? There might be requirements that are imposed upon that owner in relation to the permit relevant to the use of the road.
Yeah, we've gone down the council path already.
But you've gone down the council path already in terms of preventing the development or putting conditions on the development?
Putting conditions on the development.
Were the conditions relevant to the use of the road?
No.
No. Well, then that's where I would address the. If that's what you're really concerned about, Brian, that's where I'd start the discussion.
Yeah. Okay.
You can't stop him using the road, but if he's running trucks that are not suitable, if all of those issues, then you go along and you say it's a formed but unmade road. He's going to be running these vehicles down it for a period of X months. I'm sorry, he's going to deteriorate the road. What do you want to do in terms of making it good because you won't?
Yeah, okay.
Thanks, Brian.
All right, thank you. It's not the answer I wanted to hear.
No, I never do that.
Loud and clear.
Thank you.
Well, no, that's the answer you did want to hear, which is the good advice answer, Brian. It may not align with your interests, but it's the best advice you can get.
Yes, exactly.
Thank you,
All right,
Brian.
Jocelyn in Epping, good morning to you.
Good morning. I just have a question in regards to the actions of a solicitor. My mum has bipolar.
Yes.
And she recently went to hospital, and she went to hospital for heart palpitations.
Yes.
And the hospital wanted to do a mental assessment on her, a health assessment on her, and she rang her solicitor who ceased or prevented the health assessment being done.
So what you're describing, Jocelyn, is that your mother instructed her lawyer to act in accordance with your mother's instructions.
Yes.
So where's the problem so far?
Well, the solicitor's not a expert in mental health, so how are they making the assessment?
No, they're not. But what happens is your mum says, I don't want you to do this.
Yes.
And I'm going to engage a lawyer to make sure that my rights are respected. And so that's what happened, and the process stopped. If you believe that your mother is not capable of making those kinds of decisions, then it would appear to me that you would meet the threshold for making an application to be appointed her guardian at VCAT. So does she have a mental impairment? Does she have an impairment? As a result of that impairment, does she need assistance in making decisions? And if she does, then who ought that person be? Okay. But if your starting proposition is that my mum, 99 times out of 100, knows what she wants to do and is capable of doing it,
yes.
then the system says she should be allowed to make those decisions.
Okay.
Right? So it's really, what you're doing is you're blaming the solicitor for acting in accordance with the client's instructions.
Which is what they're in fact supposed to do. All right,
yeah,
Jocelyn?
I just didn't understand how if a medical professional wants to do an assessment,
Yes.
that could be stopped.
Well,
When-
any client, any person is entitled, 99% of the time, to refuse treatment.
Yeah, I'm learning this.
Well,
yeah.
no, you're turning it around the other way. If the medical person wants to give treatment, then the treatment should be. Well, it doesn't work that way. If you are competent, you have the right to refuse treatment and you have the right to seek assistance. In fact, there's a couple of cases that VCAT decided in the last month in relation to mental impairment and ECT, convulsive
Electroconvulsive therapy, or shock therapy as it's occasionally called. Hope that helps you, Jocelyn. Let's go to Geelong. Hello, Wally. Good morning.
Good morning, David. John, thank you for taking my call. I recently purchased a European car which accepts diesel fuel, and so I've got a 3-year warranty on the car. It's a brand new car, I may add, and I'm about 8 months into the warranty, and it turns out that the fuel was contaminated. So I proceeded to go back to the supermarket chain fuel retailer to indicate that my warranty has now been voided as per the warranty book.
Yep.
And they've suggested happy to cover your cost of
the engine rebuild and everything else that's required, and the replacement of the fuel tank.
No, they suggested we're happy just to cover the cost of taking out the fuel and $100 goodwill.
No, I say you have an action for the value that you've lost as a result of the contaminated fuel. Do they admit the fuel was contaminated?
They don't, other than by their
actions.
Yeah, only by their actions, because the $100 goodwill comes on the basis that I forego any actions, any future actions.
No, I would.
And I said, hang on a minute, that doesn't, one doesn't fit the other. And I've since had the fuel tested. On the day that I actually turned up and put my claim in, there was a fuel contamination tanks there washing out the tank, which I took photos of, and I sent it to them to say, there's someone here doing that, and but they're still focused on $100 goodwill gesture.
Wally, keep going. All right.
Have you got a dollar figure on what it's going to cost you to get all the work done to get your car sorted?
No dollar figure, but
it's not going to be cheap. We understand that, but is it 1,000, 5,000, 10,000? I don't know. What's it likely to be?
Not quite sure, but the fact that they've actually voided my warranty, John, is probably what I'm focused on, and maybe just seeking.
Wally, you've given us enough information to indicate that there's fault, and it may well be that your liability can't be properly measured yet. You might not know until the end of the warranty period what your claim is worth.
Gotcha.
All right, so there might be because there might be there's a consequence. There's a warranty that you've lost as a result of to an unrelated part of the car.
One way of measuring Wally's loss would be to sell the car in its current state and measure the difference between what he gets for the car in its current state and what it was worth in the red book, as it's called, the trade book. And say, well, I don't want a car that's not got a warranty and I don't want a car that's had to be fixed after contaminated fuel. And here is the difference between what it was worth as it was and what it should have been worth, and that's what you owe me. Would that work?
Yeah, it's some interesting GST questions, but yes.
Oh, leave those out. Oh, God, you complicate everything, don't you?
Yes, absolutely.
Do you want the car, Wally? Do you want to keep it or do you want to get rid of it?
To tell you the truth, I just want a new for old, John. I bought a car out of good faith.
And how long ago did you buy it?
8 months ago, David.
Yeah, I don't think you're going to get new for old. The question is really, I would simply put them on notice that you'll in fact consider them to be the people with the warranty.
Yeah, how much did you spend on the car, just to give us a vague idea what sort of car it is, Wally?
$75,000.
So it's not a cheap car, and it's now worth a fraction of that. With a damaged motor, it's going to cost tens of thousands of dollars to fix. Yeah. I don't know. I'd be looking at all my options, Wally, because you're talking about a considerable loss, aren't you, David?
I think you are. So I'd be writing to them and putting them on notice. And I suppose the question is, I'd be talking to a lawyer about how you might articulate a claim so you get the warranty issue, you get them to the point where they're on for the warranty, and then Yeah, the first bit's getting the engine fixed, and then the other bits as and when they occur.
Well, an engine that's been spoilt by contaminated fuel in itself is a very pricey item, and then the warranty over the duration of its, from only 8 months out of what's a 3, 4 or 5 year warranty.
Yes.
That's a considerably
Could be a
valuable
lot of
asset
money.
as well. So,
Yes.
I wouldn't be mucking around if I was you, Wally, okay?
Yep. Thank you, gentlemen. Have a good morning.
Thank
Good on
you.
you, and thank you. Yeah, very distressing indeed. David, thank you.
Thank you, John.
Our talkback lawyer, David Whiting, helping you with free legal advice.